Hi, everyone. This is Pennsylvania attorney Evan Gutman with the next video in my legal video education series that focuses on the good moral character standard for obtaining a law license. This is video 16 of the series, and the videos are based upon a book that I wrote years ago, which is titled State Bar Admissions and the Bootlegger's Son. The complete book is available on both of my websites, which are heavensadmissions.com and gutmanvaluations.com. Both websites also contain a supplement that I wrote to the book years ago. And in addition to the supplement, the websites also contain a fictional novel I wrote, which is titled Heaven's Admissions Process. It's a humorous, comical, somewhat whimsical fictional novel that compares the criteria for being admitted into heaven, and I said it's a fictional novel, the criteria for being admitted into heaven with the criteria for being admitted into the state bar and obtaining a law license on earth. So here we go with video number 16. Each one of the videos has a PDF associated with it. You should certainly be able to find it on my Facebook pages. I have two of them. One is my personal Facebook page, and the other is a separate Facebook page that will be devoted to the videos themselves. Also, I anticipate it'll be on YouTube, still working on that a little bit. And then the videos should be available on both of my websites, heavensadmissions.com and gutmanvaluations.com. So today's PDF, the subject of today's video, is titled 6 Warning Signs of a State Bar in Need of an Attitude Adjustment. These are 6 things I've come across that basically indicate, I believe, that the state bars are trying not only to license and discipline the attorneys, but in order to enhance the economic standing of attorneys overall in the profession, what they're really looking to do is seek to have a certain degree of control on litigation outcomes. And the way they do this is by implementing programs that kind of put their finger in a pie of running the law practice, in addition to ensuring that lawyers have good moral character, which most people believe they don't. These warning signs tend to flourish in times of political conservatism, and they tend to dissipate and not be used so much in times of political liberalism. So the first problematic area is law student registration. Now, when you graduate from law school and you file your application to be a licensed attorney, you got to answer a very comprehensive character questionnaire. But some states, not all states, some states have adopted a program whereby the day you enter law school, and law schools are typically a 3-year program, the day you enter law school, they start assessing your character. So the concept is that in order to indoctrinate the law student, they're not even a law school graduate yet, they're not even applying for a law license, but they're just in law school, and they're trying to ensure that the potential lawyer early on will become acclimated to and adopt the group thought methodology approach that the state bars want. Bottom line is, it's a lot easier to maintain the reins and control on a person's thought process if control is established right from inception of day one at law school. So I view law student registration and character assessment to be a problematic area and a warning sign for the law student. The next one, second warning sign, is probationary admission. Sometimes what the bar will do is they won't outright admit a non-attorney bar applicant, and they won't deny the applicant a law license. What they'll say is, we see some problems with you, so we're going to allow you to practice law, but you're not really in the bar. You're going to have probationary admission, and we're going to keep close tabs on you. Well, the problem with that is what they're really doing is they're leveraging the individual's law license. They're holding out the, quote, carrot of full admission to what is essentially a pseudo attorney. Now, if you're a client, do you want to be represented by somebody that has probationary admission? Chances are you won't even know they have probationary admission. They'll just hold themselves out as a lawyer. And the bar basically often will say, you can hold yourself out as a lawyer. We're not even going to require you to tell clients because we just want to keep an eye on you ourselves. So if you're the client, do you want to have an attorney who has only probationary admission when the opposing party you're litigating against has a full-fledged attorney? It's unfair for a lawyer's client to be represented by an attorney on probation, is my position. And it's like basically trying to control the way the lawyer will litigate by holding out the character of full admission, which can be detrimental to their client. Third problem area, third warning sign of a state bar trying to control lawyers too much. High application fees. When I became a CPA, and in many states today, when you become a CPA, I became a CPA in 1985. I became an attorney, a Pennsylvania attorney, in 1995. The application fee to be a CPA is, generally speaking, it varies from one state to another, but $150, $200, something like that. In some states, they will have an application fee to become an attorney. I've seen states that have an application fee, just the application fee, $5,000. $5,000 some states will have an application fee to try to become a lawyer, whether you're successful or not. So that's a problematic area and very unfair. The fourth area is what is known as law practice management programs. These programs are educational programs presented by state bars, usually for free, to help, and I use, quote, help in italics in a somewhat sarcastic manner, to help lawyers who are starting up run their law practice the right way. Once again, the right way, somewhat sarcastic. What they're really trying to do is, by telling the lawyer the way to run their practice, the state bars are putting their finger in the pie of the litigations themselves. It's an initial step towards further involvement by the state bar in the lawyer's practice, with the concept being that if all lawyers will use these law practice management programs, then for the most part, all lawyers will function in a largely uniform manner. They'll do things the same way because they've been taught by the same law practice management program. And of course, lawyers who don't follow the advice, quote, advice, again, italics, lawyers who don't follow the state bar's advice in how to run a law practice will often be ostracized by their peers, and that obviously has the impact of the clients they represent inevitably suffering the consequences. One of the most significant things associated with law practice management programs is the issue of malpractice insurance. Many state bars will endorse malpractice insurance companies. Now, that is somewhat that is somewhat problematic because the state bar also is vested with the disciplinary process and ensuring ethical conduct. So I don't know that they should really be endorsing a malpractice insurance company. However, there's one state, and I only know of one state that has done this. It's the state of Oregon. They not only endorse malpractice insurance companies, they have one of the most unethical and atrocious policies ever. The state of Oregon not only requires attorneys to have malpractice insurance, but they require that attorney to purchase the malpractice insurance directly from the state bar. They're not just endorsing a state bar company. They're saying the only company in Oregon that you can purchase malpractice insurance from, and you must purchase malpractice insurance from them, is from the Oregon State Bar. It's known as the PLF, the Oregon State Bar Professional Liability Fund. I think they're the only state that does this. There's a comprehensive article in my book, State Bar Admissions and the Bootlegger's Son, that is all about the Oregon State Bar PLF. It started in 1977 with the idea that it would serve as a model for other states. So far as I know, not one other state has adopted such an ethically atrocious policy. And the reason it's ethically atrocious is because, on the one hand, malpractice insurance is needed when an attorney engages in unethical conduct, and the state bar is issuing malpractice insurance to defend that attorney who engaged in unethical conduct, while at the same time the state bar is commissioned with disciplining them. So the state bar is involved in a huge conflict of interest in the Oregon State Bar PLF because they're simultaneously defending and disciplining an attorney who engages in unethical conduct, and they assert that the two divisions are totally separate, but in all fairness, I don't think anybody buys that. And the PLF has been litigated in a number of cases over the years. The fifth area that I view as a warning sign are what is known as lawyer assistance programs. These programs are generally free, offered by state bars to help lawyers who are having problems emotionally or with addiction, drug addiction, alcoholism. And the concept is that they will be providing the assistance confidentially. They will not report the lawyer to the State Bar Disciplinary Committee. They just want to help the lawyer straighten out their life. There have been cases where that confidentiality has been breached. Cases where they do report you to the disciplinary committee, even though the lawyer assistance programs consistently say, no, don't worry, everything's confidential. Well, in all fairness, quite often it ends up not being confidential. A lawyer who needs emotional help or has substance abuse problems, certainly they should seek professional help. Certainly they should seek professional help. In my view, they should not seek that help from the state bar itself, because ultimately word gets around, and it does. The sixth and last warning sign is the one that I consider the most serious. It's when state bar rules threaten a lawyer's First Amendment speech rights when the lawyer criticizes the judiciary. That's real problematic. Throughout American history, there have been three major congressional enactments that violated citizens' First Amendment rights, at least three. These are the three big ones, I think. In the late 1790s, we had what was known as the Alien and Sedition Acts, and they were adopted by Congress, applied to all citizens, and they were very quickly condemned by both James Madison and Thomas Jefferson, and ultimately repealed. The next one was known as the Espionage Act of 1917, which was right during the time period of World War I. And the Espionage Act made it a crime if you criticized government policies. So it essentially threw the First Amendment in the garbage, is what it really did. It resulted in the successful prosecution of numerous pacifists, One of the most famous espionage cases around that time period, based upon the Espionage Act of 1917, was known as Masses Publishing Company versus Patton. And that's not General Patton, by the way. It's in Patton. It's spelled P-A-T-T-E-N, not P-A-T-T-O-N. General Patton was a very well-renowned general in World War II. But this was not him. But in that case, Masses Publishing Company, the government asserted that a comical cartoon that was labeled as Congress and Big Business, quote, that's what it was labeled, Congress and Big Business, and it was a comical cartoon, the government contended that that constituted espionage. The third one is the Smith Act of 1940. And the Smith Act of 1940 prohibited teaching, advocating, or abetting communist doctrine. In the 1990s and early 21st century, and very prevalent today, the new way, last 30 years anyway, the new way the state bars seek to prohibit and curtail a lawyer's fundamental right to criticize the judiciary is by adopting rules that contain disingenuous state bar notions of, quote, civility and professionalism. The problem is that when you say a lawyer has to always be civil and professional, it tends to then make passionately disagreeing with an opposing attorney a viable threat to your own law license. Irrational characterizations by bar committees when assessing moral character have been that the applicant has been disrespectful, uncivil, glib, facetious, sarcastic, or arrogant. These are ridiculous notions to deny a law license. The way they do it is when they say the applicant has been uncivil or unprofessional or disrespectful, they call it, the phrase they like to use is they engaged in conduct prejudicial to the administration of justice. But most of the time, it's not conduct to the administration of justice. Maybe not most of the time, but at least a good proportion of the time, it's not conduct prejudicial to the administration of justice. It's conduct prejudicial to the administration of injustice. Injustice, not justice. If lawyers can't exercise their own constitutional rights, then how can they protect a client's constitutional rights? Neither lawyers, nor judges for that matter, in my view, nor judges. Lawyers and judges do not check their First Amendment constitutional rights at the state bar doors when they become an attorney. They still have them, and they can criticize as they deem fit. So anyway, I hope you found today's video interesting. Once again, we'll have another one within the next day or two or three or four, somewhere along those lines. And remember, love right, don't fight. Bye.